Hello, everybody. Welcome to the webinar on constitutional innovations on animal rights and the rights of nature. My name is Giovanna Gismondi, and I'm going to be the moderator today. I'm currently a visiting associate professor at George Washington University School of Law and a fellow for the Environmental Law Program. Today, we have a distinguished panel of experts that will be discussing topics of animal law and the rights of nature. So joining us, Kathy Hessler, Assistant Dean for Animal Law at George Washington University School of Law. Kathy will be providing an overview of the role of law in protecting animals, as well as challenges in using law to protect animals or to establish rights. Then Hugo Echevarria, who is an Ecuadorian lawyer and the co-president of the International Association for Constitutional Law, Rights of Nature Group, will be offering an overview of the rights of nature and animal rights from the equatorial perspective. And his presentation will also include some evolving legal frameworks in Latin America. And finally, Marcia Condoy Truyenque, who is a Peruvian lawyer and a doctoral researcher at the University of Helsinki, will be providing an overview of current jurisprudential developments advancing animal rights in Peru. So each panelist will have between 15 and 20 minutes to make a presentation. And if you have any question, please drop off your question in the chat box, since I'm going to be collecting questions. Without further ado, Kathy, the floor is yours.
Thank you. Thanks so much for organizing this event, and I'm delighted to be on with my wonderful co-panelists. So as Giovanna said, I'll be talking a little bit about an overview to help us understand where we are legally and why we need a conversation about animal rights and rights of nature. So our current legal framework, the legal systems that we have around the world have many similarities, even though they have a lot of differences. The laws tend to be written by and for people with power. Therefore, we have a challenge to create and enforce laws for marginalized and vulnerable human communities, the environment, and non-human animals. While our social understandings about the need to protect these communities is growing, the legal frameworks that we have still constrain our ability to include animals in this community of legal protection. So what does that look like? Right now, across the globe, animals are default legal property. That's their status in countries around the world. This is a contested status, it's an evolving status, but that's our starting point, is that animals are property. Animals are deemed owned, either by individuals and corporations as private property, or by governments in terms of their managing the wild animals. And ownership does not require responsible care, at least not in terms that we might understand responsible care. Owners can regulate all facets of animals' lives. They're not required to protect them from harm, and it's permissible for them to inflict harm on these animals in terms of using them for research or food production, entertainment, and other uses. Animals are not seen as self-owning, right? They don't get to control their own destinies. They don't have agency within the legal framework. And that is similar to some human populations, disfavored human populations, children, and others. So we have a legal precedent to see how we deal with those populations. And we have a potential way of thinking about this that's different than our current way of thinking about them. Animals, because they're seen as property, are also seen as resources, and resources that are plentiful, that are designed to be used for humans, and frankly, only useful or valuable for human ends and enjoyment. So that's the framework that we start with. And because animals are not seen as valuable for themselves, that social construction, right, is also a legal construction. So the law doesn't know how to attribute value to animals without human benefit. How does the law see and value animals for their own intrinsic value? And this, again, is not unique. The law also lacks a metric to value human lives and the natural world. And what we know is when the law doesn't value something, it doesn't protect, right? So if there's no value, there's no protection, and that approach leads to abuse, neglect, cruelty, and extinction. So how can we shift this legal framework? One of the ways I suggest that we do that is by looking at science, because science helps us distinguish inanimate property from animals, right? And so we now know, and we have scientific evidence and proof that animals have all kinds of capacities that we presuppose they do not have, right? And so if we understand that they're sentient, they're conscious, some of them are proven to be self-aware, right? That they have complex cognition, memory, and family ties, and all of these kinds of things, then that begs the question, what are our duties with respect to these capacities? Once science has shown us they have these capacities, then we have some legal conversation, right? So if we know that they're sentient, if we know they can feel pain and have cognition and self-awareness, then we can accept this science, right? New ways of thinking about animals that take them out of that property context, right? So that requires a shift in our approach to them. So I suggest in the law, if we know that animals are sentient, for instance, and have these other capacities, that should result in legal protection, right? So we already have an existing duty, generally speaking, to avoid unnecessary harm and suffering. We can talk about what's unnecessary and what's harm and suffering, but we also need a duty to impose on ourselves to use alternatives to animals when that's possible, right? So if we know that we could harm them, then we shouldn't harm them if there are alternatives to that behavior. So we need to shift our default and thinking about, let's assume behavior will cause harm. Are there ways around that, right? How can we think about reframing our legal duties to them so that we don't cause them harm? So there are an increasing number of scientific studies that talk about sentience and other capacities, and this science is already having an impact on the legal realm. So in the UK now, all decapod crustaceans and cephalopod mollusks, including all vertebrates, have legal protection and are recognized as sentient. Spain has recognized some animal sentience in their criminal code. They've also added some recognition in their civil code through legislation for companion animals. Germany has recognized sentience and suffering in some legal frameworks. There's a case in Canada where the judges noted that animals are living, feeling beings. We have in the United States something called the Port Townsend Proclamation that recognizes southern resident orcas as special categories deserving of special protection. And we have 21 countries that, in whole or in part, recognize some sentience in their legal framework, okay? So the science is beginning to shift our legal frameworks in thinking about and addressing animals. So how is that evolving law shifting? Well, we've been thinking about for a long time now, what should the legal status of animals be? And there are many conceptualizations. So some people think property is appropriate. Some people would say property plus or living property. There's the animal rights framework, talking about animals as rights holders. We have Pachamama or indigenous approaches. We have ethical approaches like ecofeminism and deep ecology. We have a tribal rights approach, which is sort of in addition to indigenous perspectives. And we have the rights of nature, right? So we have these evolving theories, and most of the ones I've just mentioned don't have much legal purchase. They aren't successful, and rights of nature is becoming more successful. So that's why my colleagues will be talking about that more in a minute. And so again, just to give an overview about how that conversation is taking place, in our constitutional frameworks around the country, many constitutions around the world, many constitutions already include protections for the environment. And they designate that in a number of ways. They use different language. The scope of the protection is different, but many constitutions already recognize as a duty for the country to protect the environment. Some also protect animals specifically. So some assume that animals are subsumed in that environmental protection, but they don't call that out specifically and they don't clarify that. But some actually designate protection for animals specifically. So there are 51 countries that I was able to find with specific mentions of animals in their constitution. The US is not among them. Countries like China, surprisingly, are. So it's interesting. And I did not do a survey of indigenous communities who have their own constitutions and legal frameworks. So it's important to see the animals in these frameworks, right? Specifically, in addition to the notions or the comments about the environment, because they have distinct legal status or should. And their need for legal protection is similar to and related to environment, but also distinct and needs attention, okay? So giving meaning to these constitutional elements that exist is already difficult, enforcement is difficult, and that could be a whole additional webinar. But I want to just give you a sense of what's around. So in the constitutions that I examined, the language that protects animals, some of it is very vague, protecting fauna and flora and their habitats, preventing extinction, protecting harmony or harmony with nature, protecting nature, creating an environment that's suitable for the development of living beings, restoring or maintaining ecological balance, protecting, conserving biodiversity, and establishing management plans. So a lot of the constitutions have this really vague language that's quite difficult to know what to do with. Some constitutions have amazingly specific language with respect to animals. So Austria actually includes the term animal protection. Bolivia protects domestic animals as well as wild animals. Egypt requires protecting green spaces in urban areas and preventing cruelty to animals. And these, again, are in the constitutional framework. It's pretty amazing. Papua New Guinea protects birds, animals, fish, insects, plants, and trees. So really calling out all the beings. Sweden makes it unlawful portrayals of violence against animals and people violation. In Switzerland, they actually include the duty to fight diseases that affect animals and plants. And Venezuela wants to be working towards pollution-free environments with living species receiving special protection. So some really different kinds of language. When we begin to think about what animals might need, you see that there's a lot of things we could be talking about. So these create duties, right? These inclusion of this language creates duties. And of course, we have exemptions. So the duties aren't necessarily clear, and the exemptions often follow right behind the duty, right? So what do those exemptions look like? So we're going to protect the animals, yes, and then we're also going to allow for development, exploitation, and use of natural resources, including those animals. We're going to allow hunting, fishing, trapping, forestry regimes, use of animals as aquatic resources, and energy programs. So we're sort of giving with one hand and taking with the other. Right? And so we're at a point where we have to figure out that dissonance. What does that actually mean? What is the legal system going to do about that? And what protections will animals really have? So that comes down to a sort of constitutional interpretation problem, right? And so my colleagues will talk a lot more about this, but again, I just want to give some quick overview. So here it's important to consider that the judges who are handling these cases and hearing them are not coming from animal rights perspectives. And the same is true for the legislators who are including these provisions in either state or national body pieces of legislation or in the constitutional amendments and frameworks. But rather, the judges looking at this are coming from their own constitutional expertise. So they're saying, all right, we have now this language in our Constitution. What does it mean? What do we do with it? How do we apply it? And so we're getting some really fascinating cases to be thinking about. So we have a case in Pakistan where an elephant was freed and a zoo was shut down because that's what the judge thought was required based on the constitutional language. We have ongoing conversations about lion protection in South Africa. The German Constitution grants some animals certain rights, and we haven't had much litigation around that just yet. The Balearic Islands effectively give legal personhood to grade 8, and New Zealand and India have recognized rivers as legal entities. In Argentina, we know Sandra was orangutan was released from the zoo. In Brazil, Suisa was the first animal who might have been deemed a legal person. And there's more that we could talk about, but I want to just give a sense that this is evolving, right? So the judges are beginning to grapple with this language and try to figure out how it should be applied. In the US, we have efforts to stop the rights of nature. So there have been legislative attempts to protect nature. And in the US, sometimes it had been nature, sometimes it had been animals and nature. But we have 4 states that have basically said we can't do that in our state. We've had 2 states that we've had judicial denials of the rights of nature efforts. However, so it's not going very well in the U.S. right now. The slight good news is that in tribal communities in the U.S., there are recent success. So the Yurok tribe is protecting water and salmon specifically. The White Earth Band of Ojibwe are protecting wild rice, and while that's not an animal, I think it's still precedential and valuable. The Navajo Diné people have a broad rights articulated in their constitutional framework for animals. The Sauk Seattle people have protected salmon's right to spawn, and we have some other matters that are pending. So I think this is a really ripe area for consideration. These are jurisdictions we can learn from, and we can work with in thinking about how to protect animals in a sort of rights of nature framework. Okay, so why is this important to do? Well, if we don't consider animals' interests, obviously it hurts the animals, but it hurts the environment. It impoverishes the development of law. It hinders the creation of appropriate mechanisms to restrain the cruelty and abuse that humans do inflict on animals. It constrains broad understanding, conceptualization, and implementation of animal protection measures, the ones that we do have, as well as our understanding about how animals do fit into these. And it deprioritizes enforcement of the laws that we have. So doing better takes significant effort to overcome these current paradigms, but there are ways forward. If we begin to realize that animals are not property, are not products, and are not ours, that's a different framing that helps us think about new ways forward. If we stop seeing animals and the natural world primarily as resources for human use, that will help. We need to include animal interests explicitly in our decision making, accept the science that shows that non-human animals feel and have capacities that we need to acknowledge, accept our legal obligations not to do unnecessary harm, specifically relating to those capacities, and reframe our relationship to animals within the law and other disciplines, within the natural world. And we can learn from indigenous people's relationship with animals as we do. So my colleagues will address rights of nature as a solution as one way forward in specific instances. Thank you.
Thank you so much, Kathy, for your insightful presentation about evolving jurisprudential developments and challenges in protecting animals using the law. Next, Hugo Echevarria will make a presentation on the Ecuadorian legal system and some evolving legal frameworks in Latin America.
Thank you very much, Professor Gismondi and Assistant Dean Hessler. I am very happy to be part of this conversation with Marcia, and thank you to all of you who are following us today. I will share now a presentation. Let me see. Okay. Can you see it? Okay. Well, first of all, yes, I'm going to talk about what is happening in Latin America, specifically in Ecuador, but I would like to provide a comparative approach in preparation of the main topic of today, which is the Peruvian model. And the context I will provide is on animal rights and the rights of nature. You will see why, because these two new trends are articulating themselves in the courts in Latin America. I would like to share with you four main ideas. First of all, in Latin America, constitutional law is shaping animal rights and the rights of nature, is providing them with content and with a scope. Second, judges, and I like this idea, I always mention it. Judges, not legislators, are the ones with the main role in this context. And this is interesting because, as you all know, Latin America follows a civil law tradition, where rights are given content by legislators, not by judges. But in the case of the rights of nature and more recently animal rights, judges are the ones leading the way. In the third main idea I want to share with you is that the top courts, the highest courts in Latin America, are addressing these topics. This is very important because the highest court has the capacity to issue erga omnes jurisprudence, and their opinion is highly respected. And finally, and this is what I will lead this idea for Marcia to give an example of what is happening in Peru. Dynamic interpretation is being used by constitutional courts. This idea of adapting the law to new issues is being applied by courts in Latin America in order to adapt current legislation to 21st century challenges, including challenges regarding the relationship between humans and nature. Professor Hessler already spoke about this specific case in the presentation. It was mentioned dating back to 2010. So that's the beginning of 21st century. A Brazilian court actually granted an habeas corpus to a chimpanzee. That's the Suiza case. This case is very important to remember it because it's not known, but it's very important because it basically started all this conversation, at least in Latin America. We all know the important cases coming from Argentinian courts, including one coming from the Supreme Court of Argentina, the cases of Sandra and Cecilia, 2015 and 2016. Again, cases about the right to freedom on these primates. In Colombia, this is perhaps the most known or the best known case in the world. It's not about animal rights, but the rights of nature. The Atrato River decision issued by the Constitutional Court of Colombia, granting rights to a river. And that decision became a pioneer decision, which was followed by many other cases in Colombia regarding river rights and other ecosystems. Then we come to my country, to Ecuador. As you all know, Ecuador recognized rights to nature in the Constitution of 2008. So we do have a specific constitutional recognition of rights to nature. And this recognition was later on applied, litigation came, and the Constitutional Court of Ecuador granted legal recognition to a forest, Los Cedros forest, in 2021. So this is also a well-known case worldwide, and it is about rights of a forest. In 2022, the Constitutional Court of Ecuador adapted and expanded the idea of rights to nature to animal rights, and decided in a very important case that wild animals have legal rights, as the title of this news piece states. You have here the first page of the decision with all the data, and indeed, the case was about rights of nature and animals as right holders. This is a 2022 case. I will explain a little bit about the content of this case later on. And in 2024, a Peruvian court adapted their constitution to recognize rights to a fox, ron. So with this recalling of case law in Latin America, I want to highlight to you that something is happening in courts in Latin America. And the interesting thing is that all these cases come from different legal disciplines, but they all end up or unite in constitutional law. So you have most of these cases coming from a dynamic interpretation of environmental principles and rules in their constitutions of these countries. So it's the starting point is environmental law in some cases. In other cases, animal law, for example, the concept of sentience is protagonic. So you see the role of animal law also as part of this dialogue of the courts. And in other cases, you see the rights of nature, which is a trend, is an emerging idea. But all of these disciplines come together in constitutional law because the constitutional courts and the constitutional judges are applying constitutional law principles and rules in order to adapt these disciplines and to combine these disciplines as well. Now, this is a very important idea for me to continue with the presentation. It is all about constitutional law. And this idea is not mine, actually. This was acknowledged by the Inter-American Court of Human Rights. And please take note of, this is a court specialized on human rights. And in 2027, the Inter-American Court, in an advisory opinion regarding human rights and the environment, acknowledged that the right to a healthy environment, you see the language of 100% human rights, includes other components of the environment, such as rivers, seas, and as legal interest in themselves. Okay, so the court also acknowledged that these elements of nature, they call it environment, because the San Salvador Protocol refers to environment, not to nature. But the court expanded a little bit the idea and said that these elements merit protection in themselves. And the third idea is very important because this is actually a quote from the paragraph 62 of this advisory opinion. It says that the court notes a tendency, not only in judgments, but also in constitutions, like it is the case in Ecuador, to recognize legal personality and consequently rights to nature. And this comes from a court, an expert court in human rights. So you see, the ideas are changing and the judges are welcoming these new concepts, or at least acknowledging these new concepts. And here's a quote taken from the Marañón River decision. The Marañón River decision is a decision adopted by an appeal court in Peru, and this appeal court refers to this precedent from the Peruvian Constitutional Tribunal. So the Constitutional Tribunal is the top court in constitutional law in Peru. And you see the Constitutional Tribunal of Peru interprets their constitution, which does not recognize rights to nature nor animal rights, but they approach the environmental law section of their constitution in such a way that they conclude that elements of nature, elements of the environment deserve protection for a variety of reasons, not all of them exclusively dependent on human interests. So you see, and this comes out from a constitution that only addresses environmental human rights. But you see an effort of these judges to expand this idea to new trends. And this is a very important paragraph of the Estrellita case, which is a case on animal rights and the rights of nature in Ecuador. This paragraph is very important, so if you would like to read it for a few seconds. The Ecuadorian court said that the recognition of animals as subjects of rights is the most recent stage in the development of their legal protection. So beginning from with the idea of property, then the idea of animal welfare, then the idea of wild animals, wild fauna and protected fauna, and then animal rights. So the court in Ecuador addresses this as an evolution, from an evolutionary perspective. So this is very interesting because the court concludes that recognizing rights to animals is a synthesis, not an antithesis. It's like the consequence of the other steps, other stages. And another idea is important. This is a work in progress. See, this by no means this is finished or concluded. These are ideas that needs to be progressive and also perfected. Okay, so as you can see now in Latin America, it is very clear that constitutional law is the preferred, I will not say the only, but the preferred avenue to address these new topics. Second idea is that constitutional principles and rules are in application in order to solve or to decide on these new cases. So these are constitutional cases that include elements from environmental law, from animal law, and also from the rights of nature trend. But the nucleus, the core of these cases is constitutional. And the third point, which is of most importance, is that dynamic interpretation of the law is in place or is applicable to adapt the current framework to new challenges. And this is, in my opinion, this is the most important contribution of comparative constitutional law coming out from Latin America. The judges are not afraid to sit down and see the law with new glasses, if one may say. And of course, the decisions are not perfect, by no means, but you can see a true effort from judges to try to adapt the law to new problems. So, okay, I go now to Ecuador in order to tell you what happened with this idea of animal rights and the rights of nature. By 2020, you might recall that in 2008, Ecuador moved forward to include the rights of nature in the constitution. So we have a constitution that acknowledges both human environmental rights and the rights of nature, with nature as a new legal subject herself, with the specific rights of existence, persistence, and restoration. So by 2020, so a decade later, 10 years later, more or less, the leading opinion in doctrine, in academia, even in courts, was that nature is to be addressed as a place, as a location. For example, a river, for example, a forest, an ecosystem, if you may. But questions began to be raised on what about elements of nature? For example, trees, not the forest. For example, the fish in the river. And then animal rights groups began raising the question, what about animal rights in the context of the rights of nature? And this is exactly the question that the Constitutional Court of Ecuador addressed in the Estrellita case. Should animals be recognized as right holders by themselves under the new idea of the rights of nature? That was basically the idea. And I'm sure you will all by now say, yes, you know, it's logical, it's a basic question, but turns out that it was an issue for debate. Okay? In 2000, so The Estrellita case is probably you all know about the facts, but just to make sure that everybody is has the knowledge of this, it's a very complicated case because Estrellita was a monkey who had lived with a human family. Sorry if I'm not with people, with human beings. But the verdict refers to the holders of Estrellita as a human family. Okay, so this Estrellita lived with them for 18 years. And she was forcibly seized by the authority on the grounds of possessing a wild animal because that's not legal in Ecuador. So the environmental authority went to that house and seized the animal. Estrellita was relocated in a zoo, and she died within 2 months. A few days later, she died there in the zoo. So a habeas corpus case was filed, and the case was lost both in the first level and in appeal. And interestingly, in 2020, a year later, the Constitutional Court itself, selected the case ex officio because the court decided that this case will provide the opportunity to address the question on whether or not animal rights are to be included in the context of the rights of nature. So please, I know this is procedural law and this might be a little complicated, but the important idea that I want to share with you is that this case was selected by the court. It was the case was not, the plaintiffs did not ask the courts to address this case. But the court itself decided that this topic was so interesting, was important, that the court selected the case ex officio in order to address this legal question. This is a power that the Constitutional Court has, and it has used in several times in order to address issues that are important for Ecuadorian society. Okay, so it was an ex officio decision. In 2022, the court decided that the scopes of rights of nature includes animals. Okay? Under this idea that if you protect nature, you are also protecting not the ecosystem, but also the elements of the ecosystem, the components of nature, if you may. Okay, so, and this is, I have preserved the original language in Spanish. The court says that, yes, they acknowledge that nature is a new rights holder in herself, but that legal status is shared with all her elements. Okay? So this is very interesting because later on the court has followed with this idea in order to protect elements of nature. Reaching to the final part of my presentation, you see the dynamic interpretation of the Constitutional Court of Ecuador within the realm of rights of nature. While the first approach to rights of nature was the ecosystem, was a place, was a location, the court said, I will expand the notion of the rights of nature or the scope of the rights of nature also to their elements. Okay? In Peru, unlike Ecuador, their constitution does not recognize rights to nature nor rights to animals. This is a very important difference to be made. Nevertheless, their judges in their top court are making, at least in my opinion, reading these decisions from somebody who is not from Peru and not familiar with their specific legal system. But nevertheless, what you can read there is that they are making an effort to adapt their constitution to these new topics. And this is exactly what you see in the Atrato River decision from Colombia. Colombia also, their constitution does not recognize rights to nature, but their court did adapt their environmental provisions to these new ideas. And if you read the decisions, while not perfect, Marcia will tell you all about it, it is interesting to read arguments that could be categorized as persuasive. And what is of most interest for me is their arguments are based upon their own constitutional jurisprudence. Okay, so you can see that their constitutional tribunal is building up a new doctrine and a new judicial doctrine on these new topics. And with this, I conclude. Thank you very much. If you have any questions, I'll be happy to answer in the Q&A section.
Thank you so much, Hugo. Thank you so much for that amazing overview of legal frameworks in Latin America concerning rights of nature and animal law. Now we turn to Marcia, who will talk about the Peruvian legal system and evolving decisions on animal rights. Marcia, you're mute.
Oh, thank you, Giovanna. Please, can you see my slides?
Yes, but it shows that very tiny.
Oh, what about now?
Yes, that's it. Yes.
Yeah, perfect.
Thank you.
Perfect. Well, thank you so much for the invitation, Giovanna, Professor Katie, and Hugo. Today, I will address the constitutionality of animal protection in Peru. And this presentation, of course, is done with the occasion of the recent judgment in Peru about the Run Run case. That is the first judgment in Peru that explicitly recognizes rights for animals in Peru. So let's start saying that, first of all, Peruvian constitution is centered in human dignity. As you can see, Article 1 established that the defense of the human person and the respect for his dignity are the supreme purpose of the society and the state, end quote. So, having the human dignity proclaimed in the first article of the Constitution gave the impression that Peruvian legal system is purely anthropocentric. Also, as Hugo mentioned, no right in the Constitution is referred to animals. Nevertheless, as I will explain, animals are not excluded from the Constitution, mainly because of two reasons. The first is because of a relational approach recognizes that human-animal relationships are integral part of human rights. And the second reason is because the Constitution has underlying values against cruelty, pain, and suffering. Of course, I will base all my arguments in the existing case law of the Peruvian Constitutional Tribunal, that is the most important tribunal in Peru. I will say the most powerful power in Peru. So let's start addressing the relational approach. Because for the Constitutional Tribunal and many other constitutional courts in Peru, many human-animal relationships are an integral part of the exercise of constitutional rights. Therefore, such human-animal relationships have a constitutional connotation. They are protected by the Constitution. And for explaining this, I will use the most evident example of our relational approach, that is the right to have a pet. In 2018, the Constitutional Tribunal declared that the right to free development of the personality contains the right to have a pet. In the case in file 1413-2017, the plaintiff denounced that the building where he was living with his pet In this building, it was prohibited the use of elevators for the circulation of pets. Thus, the plaintiff was forced to go up and go down using the stairs from the 16th floor in which his apartment was located. And this, of course, was affecting the health of his dog, especially the joints. In this case, the Constitutional Tribunal recognized that although the prohibition of use elevators in the building was aimed to protect the safety of people and that the building was clean, such prohibition was violating the right to free development of the personality contained in Article 2.1 of the Constitution. Very briefly, the right to free development of the personality is a right that derives from the autonomy that recognizes and protects the capacity of every human being to decide about his own life, as long as these decisions don't affect others, the rights of others. For the Constitutional Tribunal, the ownership of a pet is a manifestation of the right to free development of the personality because it is up to each individual life plan to decide whether to have a pet or not. So the decision to have a pet is part of your privacy, and the state or others do not have anything to say about it. Regarding the right to have a pet, the Constitutional Tribunal stressed, I will read this quote, although for some the ownership of a pet may seem a minor or even a banal decision, for many people, to a greater or lesser extent, it can have an important meaning in their life, developing certain affective and emotional bonds with their animals, end quote. In 2019, in the ruling in the file 7392 of 2013, but this was resolved in 2019, the Constitutional Tribunal again pointed out that the right to have a pet is a right that derives from the right to free development of the personality. In this case, the tribunal said, to the extent that the right to the free development of the personality protects the freedom of action of every person oriented to achieve their own personal fulfillments, the possession of a pet on a personal basis or within a family constitutes areas of freedom or faculties inherent to the structuring and realization of the private and social life of a person. In this case, the court went further and even made explicit reference to the emotional ties between humans and their animals in the family context. Quote, the court cannot ignore that in the case of non-human animals that live as pets with human beings in the context of their personal and family intimacy, the bonds of affection and empathy that are built between them reach levels that are close or even similar and or greater in some circumstances to those established with any other member of the family or social environment. Thus, in addition to the right to have a pet, the right to have a multi-species family has also been recognized by the Constitutional Tribunal. In fact, currently, in Peru, we have several judgments that explicitly protect the existence and the existence of a multi-species family. So there are many cases. There are one case that I like a lot in which the court protected a multi-species family in which the animal was a big pig living in an apartment. So we have the right to multi-species family recognized already. In other words, although animals are not direct recipients of or beneficiaries of the constitutional rights, the enjoyment and exercise of such constitutional rights includes relationships with animals, and those relationships must be protected, and consequently, we have animals indirectly protected by this relational approach. But is that always true, that a relational approach will always protect animals? Well, let's see what happened in case with another right. in which the court, instead of protecting animals, has legitimized the use of animals as objects for research. In the ruling of the file 7392 of 2013, the Constitutional Tribunal indicated that the right to freedom of scientific creation, recognized in Article 2.8 of the Constitution, includes the use of animals in many cases. The court said, quote, in certain circumstances, the experimentation with animals who are alive may be required for research with scientific purposes, which will be permitted in exceptional cases and provided that experimentation through other means is not possible, among other exceptional cases regulated in the animal protection laws. So, how to avoid these unwarranted results from a relational approach that, instead of protecting animals, will legitimize animal exploitation? Well, an answer from my point of view could be seen in how the Constitutional Tribunal has interpreted the right to a healthy environment in order to protect animals for their own sake. The Peruvian Constitutional Tribunal established that the right to a healthy environment, recognized in Article 2.22 of the Constitution, means more than protection of the environment or protection of the nature, but it fundamentally means the protection and preservation of harmony and peace, including with animals. Well, I will read this part that I didn't consider here, it seems. Yeah. The Constitutional Tribunal said specifically, quote, the fundamental right to a healthy environment implies the right of persons to an environment in which its elements develop and interrelate in a natural and harmonious manner. But human beings must also act in harmony and peaceful coexistence with other living beings around them, especially towards animals. Now, I would like to highlight that especially towards animals, because to support an special treatment towards animals, the Constitutional Tribunal looked at foreign literature, case law, and legislation regarding the moral and legal obligations towards animals as sentient beings. The Constitutional Tribunal concluded that the realization of the right to a healthy environment imposes the constitutional duty to ensure that people do not act with violence towards other people, nor with cruelty towards animals. So this is the way how the Constitutional Tribunal has interpreted the right to a healthy environment, that we have to maintain a peaceful coexistence between humans, but also with animals, especially because they are sentient beings. Now, in 2019, the Constitutional Tribunal went further, arguing that animals are also protected from cruelty based on what I call the principle of proscription of cruelty. That is an underlying value or an underlying principle in the Constitution. In the file 7392 of 2013, the Constitutional Tribunal pointed out that there are underlying values in our Constitution that reasonably apply to animals. And I would like you come with me through these lines, following the rationale of the Constitutional Tribunal. First, the Constitutional Tribunal said this, quote, if we have that the Constitution enshrines the duty of the state and of individuals to respect life of people, their physical and psychological integrity, if the Constitution prohibits all unjustified forms of physical and psychological violence, torture, inhumane treatment, humiliation, if the Constitution prohibits slavery, servitude, human trafficking, among other sufferings, it is reasonable to affirm that the production of pain, suffering, and cruelty towards humans is a transcendental and constant concern for our Constitution, which requires regulating measures that prevent them and can abolish them. The elimination of all forms of physical suffering and cruelty against humans has been the justification for the most basic forms of protection of modern legal systems with a liberal tradition. Now, just to make a summary here, the Constitutional Tribunal is saying that behind the protection of, or the justification for the existence of human rights or constitutional or fundamental rights is the concern for preventing and prohibiting suffering, pain, and all forms of kinds of suffering, no? So now, the Constitutional Tribunal continues saying, if the physical suffering that a human being can feel is a compelling reason for there to be a legal duty not to cause physical suffering, why should this consideration be restricted to beings other than humans with the same capacity to feel? So the court is saying that if behind the protection of rights, behind the reason of rights is prevention of suffering, why to limit this only to humans when there are other beings who also suffer? So the Constitutional Tribunal concludes this, quote, it follows from the fundamental norm or from the Constitution that it is a general legal duty of humans not to cause non-human animals disproportionate or unjustified pain and suffering. Thus, today in Peru, we can speak of the existence of a constitutional duty to protect animals, following the rationale that I have been describing. And this constitutional duty to protect animals will be an implicit duty of the Peruvian Constitution that has both, as I will explain now, an ecocentric and a sentiocentric dimension. An ecocentric because initially it has been argued that from the right to a healthy environment, peace between the elements of the environment, between the elements that surround us have to be in peace, in harmony, etc. But also a sentiocentric dimension because those obligations to maintain peace are special to animals as sentient beings. Now, it is precisely this right, this constitutional duty to protect animals that is at the core of the Run judgment. That is, as I mentioned, the first judgment in Peru that recognizes rights for animals. So a little about the background of the case. Run is an Indian fox who was sold as a domestic dog in a market in Lima. Run began to appear in videos that people captured when he was on the streets because he began to acquire a street dog lifestyle. He began to appear in videos where he was playing with other dogs, sleeping on roofs, or going around the city, etc. And as it is not normal to see in Peru foxes on the cities, in contrast to other parts of the world, the people called to Serfor. Serfor is the environmental authority in Peru. And Serfor captured Run and took him to a zoo in November of 2021. And the problem with taking Run to the zoo is that as Run was already famous for all the videos, the zoo exposed or exhibited Run since the first day. The next day, and many people went to the zoo to see Run because he was famous. And when they saw Run, they reported that Run was depressed, and they published many photos, including the photos that you can see in the screen. So Run was depressed, and a social demand for his freedom started. The people was claiming that Run should come back to nature. So following this social demand for the freedom of Run, on November 2021, so the same month, some days after Run was captured, Ipalema, which is an environmental organization in Peru, filed a writ of amparo. The request was to transfer Run Run to a wildlife rescue center so he can subsequently be reintegrated into his natural habitat. So according to the lawsuit, CERFOR did not comply with its statutory obligation, according to which wild animals that are seized or rescued by the environmental authority must be released or rehabilitated in order to be released. And only when the animal cannot be released, the environmental authority can transfer the animal to a breeding center, including to a zoo. But in this case, instead of making an analysis of the situation of Run Run to see if he was able to be released, CERFOR simply proceed to deliver Run Run to a zoo, clearly breaching his statutory obligation. So such a statutory obligation, the breaching of this statutory obligation was able to be challenged through an administrative process, but instead, what IPALEMA did was to challenge the constitutionality of the acts of CERFOR of putting Run Run into a zoo. So just to make a brief analysis of what is the process of amparo or this constitutional process, as Hugo was explaining, is that constitutional processes are the most useful processes in order to protect fundamental rights, but also in this case to protect rights of nature, or in this case animal rights, because the process of amparo and other constitutional process have unique advantages, such as they are free, for instance. Also, any person who considers their constitutional rights violated, even when this indirectly, any person can file a suit. Also, the amparo process or constitutional processes are resolved very quickly. And also the constitutional judges have a lot of power. They can decide, as Hugo was explaining, they can decide to take a case into court to resolve a controversial case. Also, they have extra powers, such as, for instance, if the facts behind the case don't exist anymore, the judge can issue a judgment anymore in order to resolve constitutional questions, etc. So in this case, the court accepted the demand, the amparo writ, and based on the constitutional duty to protect animals, issue the first judgment in Peru who recognized rights to animals. And the court, in this case, the court proceeded to identify how CERFOR failure to comply with its statutory obligations, but also breaching the constitutional duty to protect animals that I referred before. To begin with, the court say that the lack of adequate prevention and supervision of CERFOR led to Run Run to be sold in a market, to be trafficked from, extracted from his natural habitat. And for that reason, for this lack of supervision of the environmental authority, Run Run was exposed to many different kinds of illnesses, because when Run Run was already in the zoo, he was evaluated by the veterinarian, and the veterinarian found that Run Run had different illnesses like distemper, anemia, or bacteria and other parasites. So for the court, the trafficking of Run Run compromised his health. And as corollary of this, the trafficking threatened his right to life and his right to integrity. I will read this quote from the judgment, quote, "Actions such as the domestication and humanization of wild animals or other treatments that are detrimental to the preservation and or conservation of wild animals, or that affect the normal functioning of their organs, directly violate the core of their right to integrity, which may also represent a violation of the right to life." Second, the court also found that when Run Run was rescued or taken off from the streets, CERFOR did not establish any measure for aimed at the reintroduction of Run Run in his natural habitat. And for the court, such neglect do not only breach the statutory obligations of CERFOR, but also its constitutional duty to protect animals, because the transfer of Run Run to a zoo, quote, created unnecessary suffering due to the animal-person contact or the captivity. So the court was recognizing that the same captivity creates suffering in the animal, and also all things that happen in captivity, such as being all the time touched or seen by people. So the judgment points out in this point that, quote, the ultimate goal of the public administration must be the return of the wild animal to their natural environment and not maintain the animal in captivity, whether for educational or scientific purposes. So finally, the resolution of the case, of the Run Run case, that is the operative part of the judgment, ordered the following. First, the court ordered CERFOR to create a protocol of appropriate treatment for animals who are rescued, and this protocol has to be integral, in the sense that it has to contemplate the phase of rescue, the immediate captivity after rescue, the treatment or rehabilitation, the reinsertion of the animal into his or her natural habitat, and the subsequent monitoring of the animal in order to see that the animal is healthy once he returns to his natural habitat. But also, CERFOR must protect in all this cycle, in all these phases, the rights of animals. The rights of animals have to be guaranteed, have to be respected. And the other order that the court ordered to CERFOR is to reevaluate the current status of Run Run in order to consider the feasibility for his reintroduction into his natural habitat or another habitat that allows for his free development. Currently, Run Run is not anymore in the first zoo in Lima, that is an ordinary zoo, but now it's in another zoo that is in the mountains in an area similar to his natural habitat, but it continues in a zoo. So it is still, Run Run is still not in a cage, but in a bigger cage, if I can say that. But it continues in a zoo. So that is the case of Run Run, and that is the rationale behind the Run Run case, and that is how the Constitutional Tribunal in Peru has constructed both a relational approach towards animals, but also integrating a sentient dimension and identifying that the prevention of pain and suffering behind the recognition of human rights also apply to animals. And to conclude, I would like to invite you to read a blog I wrote where you will be able to find more details of this case, details that I didn't discuss in this presentation. You can find this in the blog of Helsinki Animal Law Center. And also, I would like to invite you to visit the website of Derecho Animal in Peru, where you will be able to find legislation, all the legislation regarding animals in Peru, all the case law regarding animals in Peru, and also other kinds of materials. So you are invited to visit the website, and thank you so much. That's all.
Thank you very much for your presentation on Peruvian animal law. Very, very, very insightful and comprehensive concerning the latest developments on animal rights. So here I have a question about animal rights in Ecuador and Peru. And the question is, which one is more advanced in terms of protection of animals, and what are the commonalities between the Peruvian legal system and the Ecuadorian legal system concerning animal rights?
I will not say which one is more advanced, but both jurisdictions are making tremendous efforts in order to include these topics into the constitutional law block. One idea I wanted to share is that this is a very difficult task because animal law stands upon specific principles. And animal law, I must say, predates way back this new idea of the rights of nature. And the rights of nature are based upon environmental law principles. So you see the difficulties that these courts are facing upon and how important it is for these courts to be giving these responses in these cases. Basically expanding these notions, these ideas of human rights to these new realms. So I don't think which one is more advanced. I think both of them are very advanced, are not perfect. I insist on this, but and not only these courts, Peruvian and Ecuadorian, you see the Colombian courts as well. And you saw a tremendous effort in Chile, not from the courts, but from their constitutional assembly to include all these topics. Didn't happen, but it certainly was a very important constitutional law debate on animals, on nature, on oceans, on climate change.
Mm-hmm. If maybe you can help me with this, Hugo, because I would like to highlight that in Latin America, at least in South America, there is a lot of conversation between courts. So when something is achieved in Colombia, the Constitutional Court of Peru cites a lot the Constitutional Court from Colombia or the Constitutional Court from Spain. They are their favorite courts. So there is a lot of dialogue between courts, and our constitutions, I would say, are not very different. They of course, they are different, but underlying the constitutions, I would say most of the Latin American constitutions have integrated the charters of human rights. So we share a lot of human rights with different names, but with the same content. So the achievement of things is parallel in some way, no?
Thank you. Before passing to the second question, this is a very important issue to raise. There is a permanent and rich dialogue between courts, especially constitutional courts in Latin America, and all of them look up to what the Inter-American Court on Human Rights has to say about human rights. So this is a very important element because whatever one court decides is duly taken into consideration by the other courts. And this is also why it's very important for the Inter-American Court on Human Rights to be addressing these issues. Yes, they are being addressed by the logic of environmental law, which is anthropocentric, but nevertheless, they are also making an effort in order to integrate these new ideas into their human rights logic. A tremendous effort, no doubt, behind these considerations.
Okay, very interesting, very interesting. The dialogue between courts in Latin America and advancing animal rights. And here I have a question for somebody that it's apologizing because she connected a little late, but she got to hear developments in Ecuador, Peru, Colombia, and other Latin American countries. And she's asking why there are such what are the main obstacles in the United States to extend similar rights to animals?
I think there's a number of obstacles. So for one, we don't have what was just discussed, the sort of deference and reliance on other courts' jurisdictions. We don't take account of the evolving legal jurisprudence in other places unless we want to, but we don't have a habit of doing that, number one. Number two, the rights of property are enshrined in our constitutional framework in ways that is different for other countries. And so we have, and because our constitution is quite old, so we have a quite deep history of protecting property rights and interests, even over sometimes the interests of human beings. And so that history is a block, right? It's going to take a long time to sort of undo that history. And so and I would also say the social consensus in the United States is not as strong sometimes towards protecting animals, towards the rights of nature, and even sometimes towards environmental rights. So that sort of ebbs and flows in the United States, and it's also seen as more political rather than a philosophical social approach, right? About sort of who we are as a people or who we should be. It's seen as a political agenda that you either agree with or disagree with. And that makes it more marginalized. So I think we have, and then we have in the United States as a base of corporate power, some of the huge multinational organizations who depend on using animals as resources. And so they're expending significant amounts of resources and energy to make sure that rights are not offered to or enlarged to include animals and certainly even parts of the environment. And they're working to, in fact, retrench and take back some of the protections that have been offered by the courts or by the legislatures. So we have quite a complex situation in the United States, but most of our social, economic, and legal structures work against the inclusion of animals, the protection for animals in the environment, unfortunately.
Okay, and another question. Thank you so much. Thank you so much for your views on this point. There's another question here about economic development and how economic development clashes with the notion of rights of nature. And the specific question is, how are courts balancing economic development, like, for example, a mining project or a deforestation project that can be seen as a project for encouraging development vis-a-vis rights of nature. So the question is, how are courts balancing these both interests?
This is perhaps the most difficult issue that the court in Ecuador has had to address so far. We have been applying rights of nature for 16 years now. And yes, the case study for this is the mining activity that in Ecuador is expanding rapidly. And Ecuador is a country is a developing country like Peru and most of the countries in Latin America. So economic development is very important in this for the society, for the state. So far, I will take a minute because this is complex. But before the rights of nature, which is based upon the principle of ecological development, it was the model of Ecuador follows the model of sustainable development. We have the model of sustainable development since the 80s in Ecuador, since the 90s, I'm sorry, in Ecuador. The problem with sustainable development in practice, this is not a criticism to the concept nor to the principle, but in practice is that almost always environmental protection has come in second place after economic development. Okay, so what the court has said in all these cases regarding the rights of nature, namely Los Cedros case, and most recently one case regarding the artisanal fisheries zone, is that both interests do not collide, but a best balance should be made. So nature's interest should be really taken into consideration. Seriously, the court uses the word serious attention to nature. So the court does not prohibit, not always prohibit, but balance. So basically they are telling do what sustainable development model means. Do it seriously. And if that means that you cannot mine in a certain place, so that is the question. So to conclude, mining is not prohibited in Ecuador, but is prohibited in certain places that need to be protected, with prohibitions included, because those places are the habitats of endangered species, for example. Okay, and last but not least, the court has said in one wonderful case that is not known, that economic development also means protection of nature and respect of nature. Not only protection of the environment, but respect of nature. And that means higher standards.
Okay, thank you so much. Thank you so much for your answer. And here we have here the last question. And I think Marcia wants to answer that question, right? Let me read the question. It's a little extensive. And the question comes from Interspecies Voices. And the question is, speaking of shifting paradigms, have you consulted the primary stakeholders themselves? Animals, wildlife, and nature through the emerging science of intuitive interspecies communication, ICC. This topic was given keynote status at the Third World Biodiversity Forum in Davos, Switzerland, June 2024. Yes, Marcia.
Yeah, I want to say that I press answer because I want more information about that. I didn't know. I was going to ask the person who wrote this if you can send me the information about that, because it seems very interesting. I don't know what does it mean, intuitive interspecies communication, but yeah, I assume that I don't know, maybe it's related to there is another concept too, that is TAK, that is traditional ecological knowledge. So maybe if it's related to that I don't know, but maybe there are, what traditional ecological knowledge explains is that people who is living in a certain area, for instance, indigenous people, but not only indigenous people, no, but people who lives in relation to animals for generations and generations, have a special connection with them and force of communication with them. And yeah, those people who have this traditional ecological knowledge are the best persons to consult in order to establish protections to these animals. But maybe it's not related, it's because you mentioned intuitive interspecies communication. But yeah, I would like more information about that. Thank you for letting us know about that.
Okay, thank you. Thank you. We have more questions. So the next questions from Priscilla Pernat. Congratulations, Latin America. In Europe, we learn from you. Thank you. Thank you. As I'm not a lawyer, but philosopher, it's writ of amparo for non-human animals possible only if their protection of nature rights are enshrined into the Constitution. In the Slovenian Constitution is written only that we should not harm animals. So this question concerns writ of amparo for non-human or for animals, and whether that is possible.
Oh, so the writ of amparo for non-human animals, is the writ of amparo for non-human animals possible only if their protection of nature rights are enshrined in the Constitution? Yeah, maybe Hugo, maybe the same happening in Ecuador, but our constitutions, at least the Peruvian constitutions and other constitutions in Latin America, have an open clause. That means that we have, for instance, Article 2 in Peru has all the rights, a list of rights, and Article 3 says explicitly all the rights that comes from interpretation. So maybe what Hugo was mentioning, that dynamic interpretation of the Constitution. So with the time, the constitutional tribunals and constitutional courts in general have the power to recognize new rights. So even rights that are not explicitly mentioned in the Constitution, the court can say, there is now right to internet, no? Because obviously it's a necessity. That is not written in the Constitution, but obviously it's a necessity, so it's a constitutional right. So yeah, that comes the magic of the open clause articles in the constitutions.
I will just like to add a very important difference between European constitutional law and Latin American constitutional law, that the Latin American constitutional approach is open. I don't have a best word, sorry, I will use a colloquial word, is a generous approach to rights. So for example, you have open standing, yeah, and you have access to these, we call it guarantees, but these tools, such as amparo or habeas corpus, habeas data, not restricted to fundamental rights, but to all rights recognized by the Constitution. So you can apply them to protect fundamental rights like civil and political rights, but also economic, social economic rights, and in countries like Ecuador, even the rights of nature, because they are recognized by the Constitution. So the approach is generous, is open, and that is a main difference with the European model.
Okay, perfect. A question from Benedicta. Apart from cases involving wild species like Ran the fox and pets, with which there is a relational approach, are there any cases or laws or constitutional provisions directly targeting microorganisms and other forms of biodiversity? Question.
Okay, that's a wonderful question. The theoretical answer in Ecuador should be yes, because the Ecuador does not, if you take a closer look to the Constitution, does not, it recognizes rights to nature and all her elements, whereas biodiversity means is focused on flora and fauna. That's the wildlife logic from environmental law. And to date, there has not been a case specific on microorganisms, but I do know that some universities are starting to take a look on fungi. On fungi issues, it's an approach that very interesting, intellectual property and fungi, for example, from the logic of the rights of nature, but there is not a case yet, not even a submitting of a case.
And I can add very quickly that some constitutional frameworks have the protection of biodiversity written as a clause, or ecological well-being. So the language of the constitutional framework can include those things specifically or generally, but the application of those principles, we haven't gotten to that at the level of even insects, much less organisms. So we're beginning to work through. So we haven't, we deal with the animals that we have cases presented based on our priority and our relationship with them. And so it takes, and those cases are difficult enough to bring, so it will take longer before we can get to these other categories, I think.
Yeah, just to give you an idea, because this is very important, but yes, we have the logic has focused us in the animals closer to us. Never, for example, I am right now working on. I have been working for years on animals living in the ocean, such as the sharks, for example, or the marine turtles. And this is difficult for me because the logic is focused on terrestrial animals, if you may. So changing these spaces to animals that are not really unfamiliar to us is a bit difficult as well.
Okay, thank you. And here, there's no question, but there's a statement that I would like you to hear, to listen, and then let me know whether you have any comment. And the comment comes from Mercedes Manriquez, and she states that the food security of indigenous peoples depend on the ecosystems that provide food. The gathering of fruits and the hunting of wild animals is fundamental for their food security, as balancing the right to food security of indigenous peoples with the rights of wild animals.
Marcia, would you like to respond? Because I do have a response on that.
Yeah. Well, Professor Katie and Hugo have heard me before talking about rights of nature. That for me is very problematic because, for instance, in the Estrellita case, it says explicitly that nature includes predation and humans can eat other animals. But yeah, I would like to say that, okay, not only indigenous people, but every human being has the right to food. And that should not imply to kill other animals because currently there are other means. And if rights of animals will be sufficiently strong to be able to make a balancing test or a proportionality test between right to food and the right to life of animals, a proper balancing or proportionality test will say that yes, animals can feed humans, but there are other means. So killing animals is not an appropriate mean, it's not a proportional or rational way to resolve the necessity for food. And also, yeah, I would like to highlight that point, that problem in rights of nature, but yeah, maybe there are other answers.
This question has partially been answered by the Constitutional Court of Ecuador regarding the connection between the rights to access to food of indigenous people and the rights of nature. The court has said, not necessarily on rights of nature cases, but in other cases, that the collective rights of indigenous people prevails. Why? Because because of cultural values they have, and because the impact they on the animals is not high. Okay, so to a short answer, the collective rights of indigenous people prevails over the rights of nature when addressing the right of food. The other topic regarding to the right of food of citizens is more problematic, and the court has not given as yet as a conclusive response, because it was indirectly addressed in the Estrellita case, but not fully addressed, because that case was not about the right of food, but the right of freedom of animals. And this is a how do you say, a work in progress debate.
Okay, well, thank you so much. We have covered all the questions, and we are now coming to an end of our seminar today. Thank you so much to all our panelists for their thoughtful presentation, and I'll see you sometime in the future for another webinar on the rights of nature and animal rights. Exciting topic. Thank you so much. Bye-bye.
Thank you.
Bye-bye.
Thank you, everyone.
Thank you, everyone. Thank you, everyone. Thank you to all those who joined today. Bye-bye. Thank you. Thank you so much. Bye-bye.